We are starting now.
Yes, sorry for the delay, the small delay. So good morning to everybody. It's a pleasure to introduce this sixth roundtable, joint initiative between the two courses of the European Private Law and Comparative Private Law. It's a very good tradition that we have established over the years, and it's a chance to come back to the new developments of European private law, every time from a new perspective. And the perspective of this year is the one of sustainability, challenge for European private law. First of all, I wish to thank all the speakers that have accepted our invitation and who will give us a wonderful contribution about this topic. And then I would like to thank all of you, all the participants, particularly all the students, for giving us the opportunity to come back to these that are topics of our research, that we want to share with you the results. And as you see today, probably more questions than answers, because we believe that it will be you, the ones who will provide probably the most sound answers in the future. And I wish to thank also Luisa Antognoli, with whom I shared this task. I have been sharing this task for several years now, and it's always a pleasure, Luisa, and to have all the students with us on this time of discussion. So sustainability and European private law, how do they link to each other, and what are the main developments that we may expect? And indeed, we have invited our speakers to look at this new development, and to look at the commitments that have been taken worldwide, global and European level, with sustainability, United Nations Sustainable Development Goals in 2015, including the objective to promote sustained, inclusive and sustainable growth, economic growth, and the commitments taken with the European Green Deal at the European level. In 2021, we have had this regulation that we call European Climate Law, with which European Union has taken the commitment to reduce and to preserve, to ensure that there will be no net emissions of greenhouse gases by 2050. But it's not only that, it's the same concept of economic sustainable growth that has been established, so that sustainability and growth can go together to some extent. And such commitments have generated a large impact on the functioning of the internal market, as we can see, for example, for the action plan of 2020 about new circular economy, and therein also we have this call for a cleaner and more competitive Europe. So again, sustainability and growth and competitiveness shall go together in a way. Now, moving from this context today, we would like to discuss in particular one major and general issue and question: what is the role for European private law in this process of establishing new developments for sustainable growth? And the question encompasses two dimensions: a European dimension and a private law dimension, so European private law. And then a European dimension, well, probably all we know that within the Charter of Fundamental Rights of the European Union, we have studied that in classes, not only in our classes, but also in your European Union class. Article 37 establishes that a high level of environmental protection and the improvement of the quality of the environment must be integrated into the policies of the Union and must be ensured in accordance with the principle of sustainable development. So sustainable development becomes a general principle of European and human law. The question is, does it affect only public policies? I was speaking only about public policy. Is the climate law that I mentioned before only a piece of public law, or does it affect also private law relationships within the internal market in particular? And here the question is not much about whether the European Union is competent. This field, we will speak about competence later, probably, because we probably remember that environmental protection as such is also a matter of shared competence between the European Union and member states, but many other, matters and areas are actually affected by this link of between sustainability and growth of the internal market. And but the question is more about how to exercise this competence, which type of relationship will be established between the role of the EU and the one of the member states. One of the questions that will be offered in today's discussion is, should member states be free to improve or to enhance even to a better level, higher level sustainability more than the one mandated by the EU? Can member states go higher, for example, compare with the level of protection ensured through European Union law? Should the member states be encouraged to cooperate among them? This is a field in which probably we do not expect, or we do not want to expect, competition among member states, but cooperation among member states to make this challenge be addressable more equally also and more effectively. And should private regulation within this domain be also encouraged, and which combination should we expect between soft law and hard law? These are all questions that may be discussed in this field. So this is about the European dimension, but what about private law? What about the private law dimension? Of course, we may go back to the very first classes problem that we had, when we questioned whether the conventional divide between public and private law could still hold today. And this is really an area in which this conventional divide becomes very blurred, in which public law aspects are totally mixed with the private law aspect. But the very question is whether we should expect that only public policies will address this, or what is the role for private law and private law relations in this field, in a context in which not only public but private institutions, society, markets more generally, businesses, NGOs and individuals are all called to take responsibility for a more sustainable life of the society and the more sustainable engagement in markets. So from the perspective of private law, one of the main issues that we will discuss altogether is whether we need a new paradigm for private autonomy. This is something we will discuss later with our speakers. The conventional paradigm of private autonomy we are used to in private law is the one in which players are self-interested, and the only way to force them to internalize public interest concern is to use mandatory rules, right? This is what also we learn from one perspective. But do we need something more than that? Another paradigm of private autonomy that is as such able to incorporate the public concerns. So this is one of the questions that we will pose. And of course, many different areas of private law may be relevant. In a separate conference 2 weeks ago, we discussed about the new proposal of the Commission about the adoption of duty of due diligence for businesses along the supply chain, exactly to ensure the compliance with the sustainability goals and sustainability standards. And we have addressed the major implications that this proposal would have both on contract law and on tort law, on the contrast between the businesses along the chain, and on the role of tort law for establishing liability of companies towards local communities, workers, NGOs, and so on. also for breaches of environmental protection. In this workshop, we will not deal with that proposal, but we will deal with two main domains of European private law, namely consumer protection on the one side and property law on the other side. We are not afraid anymore to refer to property law as an area in which European private law intervenes. And Professor Van Erck will again entertain us and engage us in a very thoughtful discussion in this field. And about consumer protection, of course, many questions will be there. Is a new approach to consumer protection possible, where the issue at stake is not only the power asymmetry in the relationship between consumers and business, but also the extent to which the consumers may be empowered as themselves trigger for a more sustainable growth, with the possibility of moving from a phase in which the internal market is mainly business driven to a situation in which the internal market may be to some extent consumer driven, based on new powers that may be based upon sustainability goals as internalized within consumer choices. And then we will those questions based new approaches to remedies as well. In classes, we have many times underlined that remedies in the European context shall be effective, proportionate, and dissuasive. But should this criteria be applied in a different way once the sustainability is there? How should we assess proportionality or effectiveness? Should we take into consideration the sustainability concern and interest within the assessment of these remedies? And somehow we speak about that with special attention to the right to repair. And then property law. Probably in this field, one of the the question we will pose is to what extent are property rights today well equipped for new allocation, let's say, of risks, rights, and liabilities in a situation in which we need to allocate the risk and cost of harm caused by human beings in the environment. Is the right to ownership well equipped to better allocate this risk and rights linked with the cost of harm caused on the environment? And second, are preventive and recovery measures that states normally adopt to prevent the harm caused on environment, are these consistent with the notion of the right to ownership, as it is recognized also by Article 17, in a very different perspective during the course we're speaking about expropriation, right? And today we will go back to the concept of expropriation. It seems to me in a very different from a very different perspective. They used to speak about expropriation when states need to fulfill new projects, to fulfill an interest, and here we use expropriation in a very different way to prevent harm, which is a different. But again, there is a mix between individual and public interest. So these are among the main questions we wish to propose to you. And being honest, by speakers, we have been promised more questions than answers. So once again, I mean, we really rely on your involvement and your discussion, and your questions and your comments to bring in some of the answers to these questions. And the proposals that we start from the first presentation, Professor Catherine and Professor Gill. And then we will have a short Q&A session with the, answer questions to the first two speakers. Then we take a little break so that we can be refreshed a little bit. And then we will have the second two presentations and then the concluding remarks of Professor Antonelli. So this is my proposal. And if we are ready for that, I think that we are ready for the first presentation. Professor Evelyn Perrin is a full professor at the Catholic University of Leuven, teaches commercial company law and consumer law. She studied at Catholic University of Leuven and the London King's College and Oxford, having a PhD in Leuven. She started a career as a lawyer and then co-editors and published extensively in the field of European consumer law, and her interest in research has focused, especially in the last part, on sustainability and circular economy. And he has co-edited the Giurisprudenza casebook on consumer law, and been a visiting professor also in Amsterdam, China U School of Law and Beijing. So, Evelyn, I thank you for being here today. I look forward to you for your presentation about the transformation of consumer law. The very provocative question: can consumer law become sustainable? With some criticisms inside, but the floor is yours, Evelyn. Many thanks for being here today.
Thank you so much for the kind introduction, for the invitation, and for all the questions already raised. And as said, I'll probably raise some additional questions, and I'm looking forward to discussing them with you. And I very much regret not being able to be there in person today, but unfortunately too many classes at this time of the year. But well, yeah, can consumer law become sustainable? That's the question of my presentation. I wonder, and why. So I would like to have a brief look again at where we come from and how consumer law has developed, how it's currently, in my regard, still a part of the problem. And I would also like to have a look at what's happening right now. Quite a lot of initiatives are being taken. A shift in thinking is definitely occurring. Is it enough? That's one of the questions. Is this really the shift we need? And how could we go further? And does this have to happen at EU level or at national level? There is a paper that can also be distributed to the students. I will not be able to tackle everything that's on the slides here in the next 25 minutes, but I'd like to raise some questions and with you. So what I do think that I hope that everyone is that we don't have to discuss is that we have a huge problem, and there is a really an urgent problem to tackle. One of our Belgian historians has called this the what we're doing right now, the colonization of the future. We're occupying future decades with the same brutality and recklessness which other continents were taken in previous centuries, as if there was nothing in the future, as if there was no one living there, as if it were ours, as if we can just go our own way. But actually, it's not only the future. That future is much closer than many of us would have expected, probably, and not only in some faraway countries where they are experiencing droughts. And but the pictures you see there is from Belgium, a place I like to go to in the Ardennes, where we also had these huge floodings and about 40 people died 2 years ago. So it's happening under our eyes, and the question is, are we doing enough? And the question today is, of course, what about private law? And what about consumer law? Is this where we have to start? Perhaps not. We might need to start with production, but we also need to do something about consumption. And the impact that consumption has is in any event enormous. About 2/3 of all emissions are related to consumption, and our consumption choices, they have an enormous impact on biodiversity, use of land and water. The other side of the coin is that we also can have an impact by changing those consumer choices. If we look at the 2020 IPCC reports, changes in consumption have a potential to reduce those emissions by up to 70%. Changes in diet, changes in mobility, changes in the way we build, changes in how we consume instead of owning, using, sharing. It can all have a huge impact. But right now, consumer law is still a part of the problem. It is really adapted or built to a linear economy, make, use, dispose, and it balances interests of traders and consumers without having a look at the bigger picture, without taking into account externalities, what happens before you actually consume, what happens after you throw something away, as if there is something as away, it stays on this small closed ecosystem. And you see it really explicitly in many consumer law instruments. It's about economic interests of consumers. It's about balancing economic interests of traders and consumers and other interests, or for other parts of the law. So we think in silos, and we fail to see how, in the end, everything we consume is intrinsically related, comes from nature, and it's just has an impact on the habitats we're living in. So consumer law is really a reduction of reality to an amazing extent, and it reflected in everything that is out there in legal terms. If you look at what kind of information we get before actually buying something right now, it's about the characteristics of the goods. Yes, it's about calories, it's about how your legal guarantee, but it's not about carbon emissions. It's not about human rights that were infringed, or the circumstances in which your products were being made. It's not about pollution. We're not informed about what happens after we throw our fast fashion away, or what happens when we actually use our right of withdrawal. What additional carbon footprint does that create? What additional waste does it create if you return something that then cannot be used anymore? That's for different parts of the law, and that's not for consumer law to take that into account. And in a way, consumer law stands for not behaving sustainably. It was created when the consumer society was created, when mass production started, when there was more affluence, and when we could consume more, and consumption has, over the years, become something that has been seen as something very positive. More consumption is more happiness, and it seems that only lately we're starting to realize that more consumption might not necessarily mean more happiness, at least definitely not in the long term. What you also see is that consumer law and also the consumption society has reduced citizens to only this aspect of consumption, only to economic interests, and not to more ethical, more collective interests. It's all about individual interests. And it's also interesting to see that, consumer law has really developed at a time where the impact of human behavior on so many aspects, on carbon emissions, on biodiversity, on ocean acidification, has all gone in an acceleration over the last 70 years. Also interesting is that consumer law really focuses and deals with consumers as a passive player. Consumer is the one who uses, consumes the good and then throws it away. But the moment that the consumer actually starts to play an active role again, like it used to be in the past, you would have a good and then repair it, and then the next generation would use it. But as soon as this consumer starts to resell the goods, to give them a second life, to repair them, to actually produce energy, to be an active player, or consumer law does not really have a solution to that. So we have a very narrow view of what consumption is in consumer law, and of what the consumer is thinking of, what his interests are. It's about self-determination. It's about focus on individual interests. It's about enabling individual choices in a market without regard to externalities. And that's not really something that is, solely the case of consumer law. It's the case of private law more in general. If we look at our private law codes, private autonomy is the basis of contract law. It's about the power of individuals to regulate themselves, all the terms and conditions. You decide alone, no legal supervision. You give your contract the content you consider appropriate, and you're free to choose in complete freedom. So that is probably something that can't work in the long term. But it's reflected also in how consumer law currently is framed. Consumer law does not stimulate sustainable choices, and there's so many examples, and it's changing. We'll talk about that later on, but repair right now, it's the same, it's at the same level as replacement. Can't replace with refurbished goods, 2 years warranty. Why should goods only last for 2 years? And then, well, there's so many examples. Also, if you think of how our right to return is actually giving form, how easy it's being made, what rights you have during that period for return. It's only about balancing interests of traders and consumers. And I'm picking this example just to show how little attention there is for the impact of how we frame consumer law. So yeah, it's great that we have this right to look at something we bought online and then send it back. And it's true that it's up to the traders to make it free or not, but there's this commercial pressure to make it as easy as possible, and that leads to ever increasing return rates. You see the data there, and there's so much, the consumer law right now, it doesn't stimulate at all consumers to think about, oh, do we really need to buy 5 different pairs of shoes and only to try them on and then to send 4 back? You don't feel what the impact is of sending it back. It's free, and you don't immediately feel the cost of using your right of return. So there are different ways of actually shaping those rights, but this is currently not taken into account. And it has an impact of not seeing those consequences. It has a great ecological impact. One example still where I think consumer law does not do enough, and where very easily more could already be done without even changing the law. Just that one case you might know, it's the case of Slevo, where the court had to decide when you buy a mattress online and you remove the plastic sealing, can you then still return it or not? The trader argued, yeah, I can't sell it anymore. It's a second-hand good then. And the discussion was, does that fall under the exception in the Consumer Rights Directive, that if a good is sealed and you remove the sealing for hygienic reasons, then you can't return it any longer? But it's especially the reasoning of the Court of Justice that is interesting there. The court only looks at, okay, what's the balance between enterprises, competitiveness, consumer protection, exceptions to the right of withdrawal. You have to interpret them strictly. And there's a market for second-hand mattresses. You sleep on second-hand mattresses or other mattresses other people have slept on in a hotel. So, okay, you can return it. You can just remove that sealing, make it a second-hand good. But ecological consequences or impacts on footprint or on resources are just not taken into account. And it's not that there is no possibility to do that under current European law. it has been mentioned, Article 37 of the Charter has been mentioned. There's also Article 11, the need to take into account environmental concerns in interpreting, well, in all the actions and policies of the European Union. So it could be taken into account, environmental concerns in interpreting EU law. But we're not going to get there only through the interpretation, but it already shows that it's not embedded in our current thinking, or not sufficiently embedded in our current thinking, although it is in the treaties, this need to take into account also environmental concerns. And yeah, more will need to be done also through legislation. Like, I'm not going to go into that there. You can read the paper that is mentioned there, but we could prohibit free returns. We could redraft the right of withdrawal, but this is not what we're currently doing. What's currently on the table is actually a withdrawal button that would make it even easier to return your goods. So no holistic perspective there, no taking into consideration these wider concerns. But it's not all negative, definitely not. There is the Green Deal, there is the Circular Economy Action Plan, there are so many proposals on the table. There is the eco-design regulation that will get a broader scope of application, and that will not only look at energy efficiency anymore, but also at repairability, availability of spare parts. So it's definitely going in the right direction if this regulation actually gets adopted. There is more attention for informing consumers also on environmental characteristics of goods. We have also now a quite far-reaching proposal since a couple of weeks for a green claims directive that should help to combat greenwashing. There is this proposal on repair that Jubil will also be talking about. There's also all the developments in corporate law and financial law. So there is definitely hope. At EU level, a lot is happening. But what worries me is that many of these proposals also opt for full harmonization. And that's also one of the questions I'd like to well, discuss with you or put on the table. Is that what we need in this field of the law? There has been this shift in consumer law from minimum harmonization to maximum harmonization around the year 2000. It all started with minimum harmonization, and then full harmonization is now very much proclaimed because consumers would need it, because the internal market would need it. And that has been questioned already in the past. Is that really the case? Is it feasible to create one single set of rules in European private law? The answer is probably no. We have already seen so many directives, even the last ones, the last consumer sales directives and the ones on digital content, full harmonization directives. But if you then look at the immense diversity of implementation, it's an illusion to create one single set of rules. And it comes with many disadvantages, I think, this full harmonization. There's no room anymore for national experimentation. And that experimentation, it has been a source of inspiration also for European legislation. And a lot is happening right now also at national level, further reaching initiatives than what is currently on the table at EU level. Think of what is happening, or has happened in France, a prohibition of planned obsolescence, repair score, durability score, not only regulating green claims or providing for an ex-ante check of the claims, but a prohibition of fossil fuel publicity, specific requirements for carbon neutral claims, extra guarantee periods after repair. So you see all these initiatives at national level. But once the EU steps in, then that's over. Full harmonization, and the EU determines the level of harmonization. In well, the paper that can be distributed I looked into the possibilities to go beyond what has been harmonized at EU level, and those possibilities are really limited. We usually don't have exceptions to go further than the maximum harmonization character, some small exceptions sometimes. And also those specific articles of 114 that allow to go further for environmental reasons, those the conditions to be able to invoke them as a country, they are very strict, and you have to be able to show that there's a specific need, a specific situation in your country. And for sustainability, this is something that is wider than specific countries. So it's very hard to go beyond the EU measures once full harmonization measures have been adopted. So that means that national initiatives like repair scores will need to be abandoned. And I suppose when the repair directive gets adopted, and I wonder whether this is the right approach. I don't really have time to go into the details. You can read it in the paper. So I analyze in more detail whether the French fossil fuel prohibition could still survive or not. Probably it could if it's adopted only for environmental reasons, not for consumer protection reasons. But that's also, in a way, a quite illogical consequence. Belgian and French repair score, in my opinion, contrary to EU law. But given the urgency, given the uncertainties as well of how we are actually going to achieve sustainability, and given the time it takes to actually adopt legislation at EU level, all what we were talking about now is still in the phase of proposals at consumer law is concerned. So do we really have the time to exclude a national sustainable consumption policy when we need to reduce by 45% greenhouse gases emissions by 2030 already, if we want to stay within that more or less safe 1.5 degree of global warming? I would like to plead for more possibilities for national experimentation, and why not create room for regulatory sandboxes, perhaps under the control of EU institutions, where national legislatures can actually be stricter and in a specific context, and see whether certain regulation actually works. This is currently being considered in the AI Act, but we might also need it in the field of sustainable consumption. So definitely room for discussion there. The last aspect I would like to discuss with you is the question whether everything that is on the table is actually sufficient. If we look at what is being proposed, we are talking about giving more information to consumers to make more sustainable choices. We are talking about regulating green claims. We are talking about barring access for the least sustainable products. We're not talking about reducing certain consumer habits that are terribly unsustainable. Think of flying for short distances. Think of, fast fashion and the impact this has. We are not stimulating different ways of consumption yet. There is limited attention at EU level for these new business models, like you could rent your clothes already if you want to, but you will have very limited consumer protection. The protection we have is protection when we buy something, when we start leasing something. We do not have a minimum standard or a minimum set of rules at EU level. So it's all very much about business as usual, but a bit greener as usual. And the question is whether we will really get there by making our consumption a bit greener. The starting point is still very much focused on our individual interests and needs. Intergenerational elements is to some extent being introduced, but only to a limited extent, and probably we need to be even more aware of the limited resources we are dealing with, and to really start realizing that that's what we start from, and not from our individual desires, but that we have to get more realistic, and if we really want to be sustainable, what is an equal and fair share then for every one of us, and should we not redefine consumption in function of those resources instead of individual needs? So yeah, what role for consumer law in all that then? Can it still be about self-determination and about making your own choices? Probably yes, but then self-determination to the extent that it doesn't affect the choices or the possibilities to self-determination of future generations, but also of other species, to have a good life. And it has to take into account the limited resources that are out there. And also missing in the whole debate and in the whole range of measures that is being adopted at EU level is more attention for the vulnerable consumers. Maximum harmonization has also reduced the possibility of member states to protect the vulnerable consumer. If we create markets with only sustainable products, and I hope we eventually will get there, it will definitely become even more important to assure that every citizen actually has access to those sustainable goods and to fulfill his or her basic needs. So the social aspect of sustainable consumption, of sustainability, also needs more attention in my regard. So, and hopefully we will eventually be able to stay within that safe and just space for humanity. And I do think that there is definitely also a role for private law to assure that we do not transgress those planetary boundaries, and to assure that we assure that every citizen on this earth has access to the basic needs and doesn't stay in the middle of that circle of that donut where you do not want humanity to be in. So consumer law is definitely not going to reach that solution by itself, but in my opinion, every area of the law needs fundamental rethinking, and no longer to only have not only to pay attention to individual interests, but also to collective interests, and also to take those planetary boundaries into account. But looking forward to your comments, questions, and thoughts. Thank you very much. I cannot hear you. Okay, thanks.
Yeah, many thanks. There was a round of applause if you didn't hear that. And we thank you very much for your presentation. I think it's been very important to look at consumer law in a critical way, seeing that as part of the problem rather than as today part of the solution. But it can be, of course, part of the solution if we probably allow for courageous, let's say, choices. And I think it was very important to underline that not only the EU can do so, but also member states, and probably a better dialogue between the two levels may help reach these targets. And a different approach will be needed beyond the full harmonization approach. So that some leeway for member states is remained with this reason. So I think that there are many questions that may arise to us now, but I would propose that we get the questions later after the second presentation, if you allow so. And so I would call here on the table Professor Giurisprudenza, whom you already know very well, professor of University of Warwick, and also professor in University of Oxford, visiting here since 2018. This is what makes us proud, of course, and part of the commission of the law commission in the UK, especially in the field of commercial law and common law. Co-editor of the book that you know very well, the Giurisprudenza contract law, and many other publications in the field of European private law. So very happy to have Professor deal in this roundtable as well. And with the presentation that will build on the previous introduction on consumer protection, because we are still in the field of consumer protection with the contribution on sustainability goods and the associated services. Can I also have?
Sorry,
sure.
As usual, displaced.
No problem. Can I move here? So that's no. Okay. So thank you. The floor is yours. Thank you very much.
First of all, thank you very much for inviting me to take part in this roundtable and indeed to come back to Trento. It's always a great pleasure to do that. And it's also very nice to see so many of the students who I've been seeing in the other class coming today. I must confess I've been enjoying my teaching time in Trento as much as I have my leisure time. It's been really nice. Now, I wanted to talk about sustainability and in a rather narrower way, perhaps, than Professor Terrain just did, because I'm basically, as you know, just a contract lawyer, and I tend to see things through the lens of contract law only. But I have to confess that this is something of a new area for me, sustainability, and I have the feeling that we are very rapidly reaching the end of what contract law can do, at least traditional contract law. We'll have a look at some of the topics that Professor Terrain has mentioned in a little bit more detail in just a moment. I should perhaps, though, explain my title. I've said Sustainability, Goods and Associated Services, because remember, we've moved away from a simple model where people buy goods. Nowadays, people frequently hire goods as well, or the goods come as part of a package. It's often called servitization. I talked about that actually last year at the roundtable. Some of you will, I'm sorry, may bore you by mentioning it again. Where you buy a package, you get the goods and you get, for example, maintenance and repair services. That's been around for a very long time. Very commonly also, you don't actually buy the goods, you hire them. And the classic example, not a consumer example, is actually Rolls-Royce aero engines, who from the 1960s started a package they call Power by the Hour, where the airline rents the engine and they pay according to a number of hours that they use it for and so on. So it's broader than just sale of goods. But what I tried to do was, and this is, I'm sorry, the very primitive contract lawyer coming to this for the first time, tried to think about what we would actually want in terms of the sort of life cycle of goods. And obviously, we would want them to be produced in an eco-friendly way. We'd want them to be economical when they're being used. We'd want them to be durable. We probably want to enable and encourage repair of the goods rather than them being thrown away. And we're talking there about both repairs that are necessary within the non-conformity period, but also repairs that may be necessary outside that period. That leads us on to the point that Professor Terran already mentioned about second-hand and refurbished goods. They may have an important role to play. But of course, we want the goods to be repairable, and at the end of their useful life, we want them to be recyclable. And throughout this, we have to think about the role of information. What do consumers need to know? What can we encourage them to think about? And what is useless to them? Because there's always the problem of over-information. So I thought I would tackle some of those things and just see to what extent contract law might contribute something. You'll notice the one thing that fortunately I haven't talked about, because Professor Terran talked about it in very thorough detail, is the right to withdraw. I just didn't mention that one. And of course, we've got quite a lot of existing legislation. I must mention a few: the Unfair Commercial Practices Directive, the Consumer Rights Directive, I'm sorry, I'm using abbreviations on the slide, the Consumer Sales Directive, but also something which was new to me, the Eco-Design Directive. And we've got a number of proposals on the table from the EU, an eco-design regulation, which will replace the directive and be much more thorough, the Green Transition Directive, and what I'm going to call the Repair Directive, and I'll come back to that one. And all of this is in the light of the Circular Economy Action Plan and the sustainability plans that Professor Terran mentioned already. Now, it seems to me that eco-friendly production is really not something that contract law can do anything about, because really this is about, as it were, causing harm to the environment. And of course, a lot of this is national legislation against pollution and so on. But of course, it's quite hard for member states or EU authorities to monitor what's going on. And I think it's interesting that there is a directive which requires non-financial information to be published by large companies. And that now has to include a statement about their environmental policy. And the idea, I think, is that shareholders and the general public will be told to what extent big companies, at least, are actually acting in favor of the environment. But of course, your consumer is not going to know very much at all about how the goods are produced. Okay, you might buy that bunch of bananas and it says they're organic, but you don't even really know what that means. But that, if it comes to a motor car, for example, you're not likely to be able to have any useful information about how eco-friendly the production process was. So whether contract law has a role to play there, I'm not sure, but I'll come back to that point in a little bit. The same, I think, with environmental efficiency. It's not something that contract law can really deal with. What we have, of course, under the Eco-Design Directive of 2009 are mandatory production requirements for energy-related consumer goods. And they're designed to reduce the consumption and the environmental impact and of the good actually being used. And of course, you're all familiar, if you've ever gone to buy, white goods, as we call them, washing machines, refrigerators, and so on. There are these energy labels on them, which do enable consumers to do a little bit. Though how much use they really are, I'm never quite sure, because supposing the refrigerator that I am interested in is only rated B rather than A. I don't really know what that means, other than that if I leave the label on, my friends will all look, oh, he's only got a B rating. It doesn't really mean a great deal to me. I think, though, when we get to the question of durability, then we are moving back into the realms that I'm a little bit more comfortable with, contract law. And it seems to me that there are a number of points we should make. First of all, at long last, durability is actually mentioned as one of the criteria for conformity under the new, 2019 revision of the Consumer Sales Directive. Many member states have had durability on the list, as it were, before that, but it's now been brought into EU law. But it seems to me that there are a number of quite tricky issues. To say to a judge, for example, or a consumer advisor, that the goods must be durable, well, fine, but what does that mean in practice? I was quite interested to see that Professor Attimer, who has written on this, divides goods into what she calls durable, and I think it's semi-durable and perishable. And the difference between durable is that durable are things like washing machines and refrigerators, bits of machinery that are supposed to last quite a long time, or electronic goods that are supposed to last quite a long time. And what she calls semi-durable, which is, she gives the example of clothes. Well, in my family, the tradition is quite different. When my brother was 21, it's a custom when you're 21 that your parents give you a big present. And my parents asked my brother, what do you want for your 21st birthday? And he said, I want a stereo. And my father said, oh, no, we're going to get you something which will last you for the rest of your life, and bought him a suit. My father just wore and wore and wore. And I'm afraid I'm much the same. You probably saw this jacket last year and the year before that. But it seems to me that what we need to do is, rather than have those broad categories, we need to establish information about the expected lifetime of particular goods. And this is beginning to emerge. You can now discover the average lifetime of a washing machine and a refrigerator and so on. But of course, it's all very vague, because a lot depends on how well made the thing is and how expensive it is. So a washing machine, I'm told, should last between 5 years and 10 years. And I guess if you buy a Miele, it's supposed to be 12 years. And if you buy, well, I don't know, never mind, something else, it's going to be cheaper. And I think the problem will be that when we get particularly to trying to extend the durability period for white goods, for example, producers are going to say, but the problem is it's not just a question of age, it's also a question of how the piece of machinery has been treated. Has it been misused, or has it simply been used very, very heavily? I mean, my former colleague, Michael Fernston, bought a commercial model washing machine because he had 10 children. And, you know, he wore them out every couple of years and had to go and buy a new one. Now, obviously, during a certain period, the burden of proof of showing that the defect was present in the goods when they were delivered is placed on the trader. But it was only for 6 months until 2019. Now it's been extended to 1 year. But that's nothing in the life of a washing machine. How are we going to get around that problem? Well, at least for machinery, I think there is a possible answer, and that is through smart products. Products which actually will tell the manufacturer, I am being used for so many hours, as it were. The manufacturers collect an awful lot of data about motor cars, typically about industrial machinery, but I think that will happen with consumer machinery. So it may be that actually it will be possible to extend the durability period, because we will be able to assure producers that they're not being ripped off by consumers who misuse the goods. But of course, the 1 year period is far too short, as I said. And equally, we have the cut-off period. You'll remember that under the Consumer Sales Directive, member states are allowed to keep, what many of them have already, a limit that it's only defects which appear within a certain period which will give rise to a remedy. And the period must be no less than 2 years. We don't have this in English law at all. But what we do have is the second restriction, which is also present in, I think, every member state. That is a limitation period. You must commence your action within so many years. The big question is, when does that period start and end? In many countries, it doesn't start until the defect appears. But nonetheless, the claim probably has to be brought within a set period from delivery, sort of what we call in English a long stop period. But in England, the limitation period runs simply from when the goods are delivered. It's 6 years full stop. So obviously, if my washing machine collapses after 7 years, and I can prove that it was always going to because there was an initial defect or something, then I'm out of pocket. So we may need to look at those things in relation to durability. Then, of course, there's the problem of planned obsolescence. And that actually means, as I understand it, two different things. Sometimes goods are only designed, they're only built well enough to last for a short time. Well, that's really just the other side of durability. But what, to my mind, is a bigger problem is what I'm going to call the mobile phone problem, or Apple problem. People producing a new model with just little tweaks every year. And of course, everybody wants the latest model. And that really seems to me to be totally iniquitous. But what can you do about it? Well, I don't think you can prevent manufacturers from doing that. And indeed, I think there would be a lot of young consumers who would be very dissatisfied. It's only old fogies like me who are content to go around with a Nokia phone in their pocket still. Everybody wants the latest thing. But that brings us to the point that when you buy your new iPhone 13 or 14 or whatever it is, your old iPhone 12 is probably still perfectly good. And it can be resold. And what I think we need to do is to look carefully at the legislation affecting second-hand sales. First of all, sales by traders, because you can trade these things in, and often, of course, you do trade your phone in. And we need to make sure that when a consumer buys second-hand goods from a trader, they have adequate rights. Now, at the moment, the only difference on the face of it is that member states can limit the cut-off period to 1 year. And there was an interesting study by Marco Loos who compared what happens in the Netherlands, which has a 2-year cut-off period, with what happens in Germany when they've reduced it to 1 year as a way of trying to encourage people to sell things second-hand. It actually seems to have the reverse effect. The second-hand market is much better in the Netherlands than it is in Germany. But that may be something to do with, the Dutch being happy to be environmentally friendly. I'm trying to be as polite as I possibly can. But the other thing is, I think we need to think very carefully about a topic which hasn't really been broached at all, as far as I know, even in the draft common frame of reference and so on, which is one consumer selling to another. I put it C2C or peer-to-peer, if you like, P2P, because it's an area where actually the laws differ quite significantly. For example, in many countries, if a private person sells, their liability is the same in terms of conformity, but their responsibility is limited to the amount of the contract price. Whereas in the UK, we don't have, and it's going to be the same in Ireland, or nobody cares any longer what happened in the UK, but in Ireland, it's the same. There's no time limit, but the seller is not responsible for the quality of the goods at all. And I think that's an area that needs to be worked on. What I do worry about, and maybe Frederick is going to talk about this, I don't know, is whether that would be something which we would have a legal base for. Now, of course, having left, I don't actually give a toss about your legal basis. That's not your problem, but I am interested, my problem, but I am interested to see that something is done on that. And obviously, I would hope that if something useful is done, then that the UK would follow. And then Evelyn mentioned also refurbished goods, and I think that's very important. I think it is increasingly the case that you can buy refurbished phones, particularly, and laptops and so on. But I think we perhaps need to clarify exactly what that means. What rights does that give the consumer? I would think, for example, that if I buy something refurbished, that would mean that it works just as well as a new good. It may not look as good, it may have scratches and possibly chips on the screen or whatever it is, but providing it works, that's the important thing. So I think we might need to establish clearer standards as to what people mean when they say, I'm selling you refurbished goods, as a way of trying to encourage reuse. But of course, the other thing is all about encouraging repair. And here we have this proposal made in the last few weeks for a directive on repair. And we're talking about two different periods. We're talking about, first of all, initial non-conformity. That is, non-conformity that arises within the liability period, if that's 2 years. And there, the change is one that's been talked about for a long time, to try to stop consumers simply saying, I want the goods replaced, and then, as it were, throw it, the goods which were non-conforming being thrown away. And the provision is that, or the proposal is, that the seller should have to repair unless the cost is greater than the cost of replacement. And that seems very sensible. But what about defects which occur outside the liability period? Sorry, I'm using these little arrow symbols to indicate in and out, because what about defects outside the liability period? Well, the directive proposes that the producer or a distributor or an importer must provide repairs if that is possible. And if they do not do so, member states must subject them to a penalty. The producer must inform the consumer of the right to demand a repair. And member states must provide a platform on which consumers can find repairers. Now, this isn't going to apply to all goods. It's going to apply to all the goods listed in Annex 2 of the directive, and Annex 2 does not yet exist as far as I can find out. But essentially, I think we're talking about white goods, electronic goods, again, the sort of thing. And also, there's a provision that the producer or other repairer must, at the consumer's request, provide a European repair information form, which will state how much it's going to cost for the consumer to have it repaired. And that statement must not be changed within 30 days. And if the repair is carried out within 30 days, it forms part of the contract. Typical EU drafting, they've forgotten to say what happens if the repair is carried out after the 30 days. Does that mean that the price can be changed even though the consumer was never warned? But never mind, that's a sort of typical first time round drafting defect. But I have considerable worries about exactly how this directive is going to work. And I'm talking now about details. First of all, what's covered? Well, the directive at the moment just talks about defects. Does that mean a non-conformity? But what does non-conformity mean once you're outside the liability period? Does it mean if the good is no longer in the initial state, it's defective? That's not defined, and I think it's going to be quite tricky. And there's another point in the directive, they don't talk about defects, they talk about repairing damage. Does that mean a producer has to repair goods which are dropped on the floor? You know, and there is nothing wrong with the goods? I'm not at all clear. And of course, there are other problems. One being that it's a full harmonization directive, and Professor Terran has already mentioned some of the problems there. My preference, of course, is not for full harmonization, though I do realize that having different rules in different member states does to some extent impede the internal market. It's a very difficult one. It's only business to consumer, only consumer goods that we're talking about. This won't apply to small businesses who buy goods, even though I think they need just as much protection. But what I'm not quite clear about, and I've been sort of going backwards and forwards over this overnight and even while Professor Terran was talking, does the consumer have a right to demand the repair? In other words, will they have a private law remedy if they don't get the repair? Well, certainly not from a third-party referrer, because the third-party referrer can be asked to produce this repair information form, but it's stated this is something that, it's stated that the repairer can refuse to perform. So it's clearly not an offer. The other thing is that the provider of the form can charge for it, providing they warn. And I think the producer is obliged to repair, and I think it must be intended that the consumer would have a right if the producer fails to actually carry out the repairs. But there are two problems. The first one I put on the slide, which is that the producer is allowed to charge whatever they want for the repair. Well, if they can do repairs profitably already, probably they'll be doing it already. Many producers do actually have repair services which they advertise and which sometimes work very well. And if they don't want to do so, what are they going to do? Answer, they're going to charge high prices. Now, the Commission's answer to that is, well, there'll be competition from third-party repairers that will keep prices low. And I'll come back to that point in just a moment. But the other thing is, I'm just not quite clear who it is that is obliged as a matter of private law to provide repairs. Because at one point, the directive talks about producers, distributors, importers, and all the rest of the gang. But the section about the obligation to repair refers only to the producer, which is defined as the manufacturer. And of course, the manufacturer may be in China or Taiwan or whoever. And, you know, I'm nothing against Chinese or Taiwanese firms, but enforcement is going to be pretty darn difficult. So I'm a little bit skeptical about that. Let's go back to the question about competition from other repairers, because this is really important. If we want to be able to get goods repaired, it's got to be made possible for third-party repairers to do it. And with complex goods, that may not be very easy. Now, with vehicles, this has already been tackled because, you know, the EU has to approve each vehicle, and part of the approval process requires that the manufacturer allow third-party repairers access to diagnostic equipment, to repair information. They even talk about an exploded view of the car being made available. I think they mean exploded view rather than the view of the exploded car, but no one. And there's also a proposal to try to make sure that the manufacturer's IP rights don't interfere, because there have been some problems over spare parts and so on. But as it's been broadened from motor vehicles, the Eco-Design Directive requires that spare parts and information be available to professional repairers for quite a wide range of large domestic appliances. And it must be for a period ranging from 7 to 10 years, depending on the appliance, and the repair should be available within 15 days. But this is not a matter of private rights of the consumer. This is simply a regulatory requirement. But the other problem is that whether goods can be repaired seems to me to be a matter of how the manufacturer designs them in the first place. Let me just give you a very simple example. I'm still operating a very old MacBook. And I asked my son, can I change the battery? And he said, yeah, you just buy one on Amazon, you know, unscrew it. And it turned out actually to be true. I was able to do it. I'm the most cack-handed person. So I said, oh, good. So when will you have to replace your battery in your newer MacBook? He said, you can't do it. It's glued in. You can't, they've stopped you doing that. You know, that's the sort of thing that really is going to be a major problem. Now, this is where the proposed eco-design regulation comes in, because they are talking about empowering the Commission to issue regulations, they call them, I forget what the term is, directions, I think, which can regulate the durability, reliability, reusability, upgradability, repairability, possible maintenance, refurbishment, and so on, of a whole range of different types of product. Sometimes you can just see why the Brexiteers thought that the EU was a little bit overbearing. It's an enormous regulation. Now, I'm not against it. You know, it's perfectly sensible. But I think we are going to move to an era of increased regulation of what actually goes into our products, which may be a good thing. Again, it's not a matter of private rights, but member states must have penalties for infringement. But then, of course, we come back to the question of consumer information. As Professor Terran mentioned, what we need to do is to educate consumers into thinking in sustainable terms, buying products that are sustainable. But how are they going to identify those products? Well, what they're planning to do at the moment is simply to add to the Unfair Commercial Practices Directive prohibitions on greenwashing, on making false claims about durability and repairability, and add to the Consumer Rights Directive that the trader has to provide information on the producer's commercial guarantee of durability, or if there is no such guarantee and the goods are energy using, then the trader must say there is no guarantee. That it must state the period for which software updates are available for electronic goods and information about repairability. But it still seems to me that we've got a problem. even if the consumer is given this information, will they be able to act on it? The EU traditionally has placed very great weight on giving consumers information. But we know from many, many studies that consumers make very limited use of the information. And think about the problem we were talking about in class just the other day about unfair terms. How many of us have read Amazon's terms and conditions? I think Rosalia had and nobody else had. You know, I count myself in the nobody else. That stuff is very hard to digest, and it's very, very difficult to sort out the wheat from the chaff or to see the wood for the trees. And it seems to me that the way forward may be to derive symbols that the consumer can look for, symbols that this good corresponds to the requirements or this good meets certain ecologically friendly standards. And of course, if a firm uses standards falsely, then I think competitors will complain. And remember that it's not just the state that, as it were, can tell people you've got to comply with the directive. Other trade bodies can. And in Germany, I'm told, for example, that many of the challenges to unfair contract terms are not brought by consumer associations, they're brought by associations of traders who see this as a form of unfair competition. But consumer associations and regulators can monitor the various complaints. And it seems to me that this provision in the repair directive, which is the standard provision, it's in the consumer sales directive, it's in the digital contact directive, it's copied in as a matter of form, I think, saying that member states shall ensure that there is adequate and effective means of ensuring compliance. That could be really important because we're up against the old problem. Unless we're talking about very expensive goods or very, very determined consumers, they are not going to bother about the fact that they've discovered that their goods were not eco-friendly. The claim is just not worth the effort, okay? So we need somebody to act on their behalf. And I see the way forward as being that. And I think at that point, thank you.
So we're continuing our discussion, and the next presentation will be by Professor Giurisprudenza, who's professor at the Jagiellonian University in Krakow in Poland, and in Germany at the University of Osnabrück. He's been visiting professor in many universities, speaks several languages. He's been part of a number of scientific enterprises like the Common Frame of Reference Team, the Polish Committee of Giurisprudenza, the European Law Institute. So it's somebody that has a lot of experience both in terms of teaching but also in terms of research. And so I give him the floor, and thank you for being here.
Yeah, thank you so much, Luisa, for inviting me, and I'm very grateful also to Marta Santos that she has proposed me here to replace her. She does a lot of research in this area. And of course, I can, to some extent, I'm coming from a country, Poland, which is not well known for very environmental friendly approach, because it's a poor country of the European Union. And your question about the issue, what is the national policy, is extremely important for such countries like Poland. And of course, the awareness of consumers about the sustainability and the question whether I put attention to it is quite different. We're looking, oh, sorry, I'm stopping with this word. So it's quite different. Just until recent legislation, criminal law, it was quite common the case in Poland that somebody who bought a car, a diesel car, a used diesel car from Western countries, he went to the garage for removing the filter of diesel or this particle filter because it's too expensive to replace it. So it was one of the issues which shows exactly that there is a somehow different community which requires a lot of change in mental change also in working environmental awareness of consumption. Of course, it is a result of different stages of development of the society, of still some, I don't like to use this term as post-communist consequences which are still lasting in the economy, even this almost 30 years, more than 30 years, are already last. To a certain extent, I will, in my presentation, I will focus on actually one provision which Giurisprudenza presented very briefly, fortunately for me, but he said also that it's fine. I will criticize this provision very, very hard, and to a certain extent I can confirm all this superstitions about Polish society, that I will be not so environmental friendly in discussing the private law, but not because I'm not environmental friendly, but I have also a little bit skeptics about to which extent the private law and contract law in particular, private law is a different issue here. I want to be focused on contract law, may do this job, may really improve environmental effects. The directive, and I will be focused on directive on sales and on the revision which has been proposed for the right to return, and also discussing the question of the competence of the union dealing in it, and also the challenges whether this provision, as it has been suggested, is really provision which is feasible to make a change, and whether it really may lead us to more efficient environmental results and produce less externalities harming the environment at this moment. The sales directive was one of the first acts which we treat as a private law or contract law directive. The issue is not self-evident because, of course, we have to know about the European Union law. But actually, it does not distinguish between the public and private law. It has a kind of very different approach. So if you are talking about contract law or private law or the European private law, it is a kind of view from the perspective of the member states, not necessarily from the perspective of the European Union. We are talking very often about the regulatory contract law of the European Union, in the sense that it is not the same concern which the Union has by adopting a legislation which usually will be implemented into the private law scheme or codifications or other laws of the member state. But of course, the primary objective is to regulate the market and to create the internal market. It is somewhat a problem which, and today probably this discussion on environmental law, it is also a discussion about the limits of private law. What private law, whether the private law can be, without consequences, converted into this public function, into protection, direct protection of public interest. Everybody knows this distinction from Roman times about the public and private law. And of course, we are always stressing by quoting this maxim, this sentence. But yeah, of course, the private law also by its institution support the public interest. But here we have a fundamental change. We are trying sometimes to build into the system the idea of how to protect the public interest, disregarding sometimes, and it will be a little bit shown in the discussion of the STIMI provision, the interest of the parties involved. And this is something which is quite difficult to make it really operational. Of course, what we have heard today, it has impact on private law, and definitely all this also public law legislation or competition legislation, or this labeling issues and eco-design, they have impact also on the private law concepts of the lack of conformity, for example, as we are talking about in the process. Not if somebody is not complying with these requirements, we would not have the requirements for conformity with the contract are also not satisfied. So in this way, we have a direct link to the private law and contract law instruments. Also, the directive on sales, this new one, brought already in the recitals the care on circular economy and talking about the durability. So already here we have a kind of very clear statement. I'm not sure because and Hugh was pointing all difficulties of durability as a criterion for lack of conformity. What is the reference for durability? What are the goods which are durable, and we can compare with durable goods and taking the goods which does not fulfill this requirement. But also there's another question, and here we are opening probably a debate, and it could be discussed, and it cannot be solved by lawyers. We have here only kind of feelings, but it must be, of course, proven. But this proof is not easy. We have in Krakow, we have a project on environmental friendly sales law. We have also proposed some kind of revision, much deeper revision of the sales directive as here. But we were working together with also economists, trying to develop kind of models for different categories of goods and telling what will be actually environmentally efficient. And this proof is extremely difficult and probably not operable on the level of the lawmaker on very general terms. So this is already some kind of warning whether the private law may really produce an effect. Only an example from durability issue. We have in more and more a growing number of cities in Europe, also in Poland, so-called green zones. The idea that you cannot enter with certain cars which are older than something. This is a very interesting point from the perspective of durability, because it shows us that durability is not always a value. The durability of old diesel car is not a value, because the old diesel car is polluting the environment more than probably the cost of recycling of this car or so we can see that even the durability can be an issue for different categories of products. That durability means also that I don't replace a product for more efficient product. He was talking about these different categories of energy consumption. It means that I have my refrigerator B for 20 years instead of having my refrigerator AA+, which has been offered by the market. So this is also another question, and to calculate what is more efficient from the point of view of environment depends on so many factors that it becomes always almost impossible, because it depends on the system of recycling that is existing in a given place, depends on the cost of transportation, depends on the sources of energy. So everything which is somehow beyond the European, beyond the private law, and very general assumption what will be beneficial here does not entirely work. It does not mean that we should not try, but this is the first warning that we have to be more careful, and certain assumptions which we have at the beginning of the system probably do not work. We have to remember also, and there is another issue we have now, what I have displayed here. This is the only provision after this long discussion. What could be changed in the sales directive? Whether we should envisage other ideas. What are the optimum prescription periods? Should we change the presumption? What will be the result on it? What will be the result on a little bit reshuffling the remedies? What is the environmental effect of the price reduction remedy? Should we support somehow the idea of self-repair? Should we deal a little bit more with damages, because they can somehow change all effects of what we have here. But this broad discussion has resulted in very teeny revision with what we have here in Article 12. And this is somehow a provision which tries to create, not incentive, it is a very interesting provision how this has been formulated, creates, is trying to change a little bit the hierarchy of remedies of the CEILS directive. As we know, according to the CEILS directive, basically I have two main remedies in the first row: repair or replacement. The directive has an option also for right to reject, but of course it could also undermine the system here, but now it is only an option for the member states. And then we have the second row, which is the price reduction and termination. And of course we have some kind, and this is a little bit the directive, went a little bit in the other direction by relaxing the conditions for termination of contract without necessity to exercise the remedies, this essential lack of conformity, which could justify the termination at once. But nevertheless, it was always the idea we should somehow change this priority and should put on the top right to repair. The question, there are several questions related to this. Some more general questions, whether such kind of any kind of priority given to the right to repair is a good idea from the point of view of environment. From the point of view of Article 114 of the treaty, so it is really not something which do we have certainty this is covered by Article 114. I will justify my thought why it could be a problem here. And then, of course, we have particular issues of this provision, which is very unfortunately formulated, I have to say, and probably produce a lot of intransparency, actually, what kind of remedies I have. And by this lack of transparency, could be also seen as kind of impediment to the internal market. So we have also another level of difficulty with this provision. First of all, why I have a little bit doubt about Article 114. As we know, to legislate, by many sources of legislation, of course, but even if we want to keep a very high ecological level, we have to maintain the internal market. So we have to pass legislation which serves to the harmonization of law, and secondly to the internal market. This is something which is embodied. This is a paradox which is embodied into this the environmental debate. And Evelyn put it rightly on the beginning, but the consumption, the happy consumption, increase of reliance into the other markets, and we actually do something against the sustainable development or ecology. The model which will be an optimum for from the point of view of sustainable consumption and environmental friendly legislation will be a model which will create a barrier in the commerce and not to go beyond your local place, because the cheapest, more ecological, most efficient way is to buy at home and not travel too much and not forcing transportation for long distances and not trying to exercise the remedies for the long distance, of course. So this is everything what the European Union is about, talking about the internal market, is actually against the idea of sustainable development, because it tries to increase the market as such, the functioning of market, more consumption. I should rely in the other systems in order to buy in Portugal from Poland and make the transportation for long distances, which I going. So this is kind of contradiction in itself, and therefore we have this difficulty to say how to find out the balance, and most important, why the right to repair is a problem here, because if we really create a kind of priority for the right to repair, it means it requires quite close cooperation between parties. I have to bring the product, I have to get it, I have to clarify what is my issue here exactly. I have to have more friendly discussion as usual about the repair than others. What does it mean exactly? It means that if the right to repair is my primary remedy, I will discuss whether it is so under directive, but if I should firstly exercise the remedy of repair, and from seller, not from everybody, but from seller, I would like to have a seller which I have close to me. So it is something which is also creating a kind of incentive for market fragmentation and not for entire market. Of course, big businesses may organize the service centers everywhere. It is not an issue here, but of course, it also means the fragmentation of market because basically you need to provide services in the place. Or if it's not the case, and very often it's not the case, that you are sending this laptop to Taiwan for repair even, of course, then we have incredible costs also. So it is not really worthy to fight there is not really a difference between replacement and repair in many categories of products. And this is, of course, another issue we will have here, because, of course, repair could be also very costly for environment, and it depends very much on it, what kind of categories of products do we have. And it was already mentioned in the green paper, it was already that, yeah, repair, it must be a little bit more differentiated, whether the repair is really worthy to go for, or it maybe we have much more issues, because of course it does not mean that that repair does not produce waste, for example. It does, because of course if you have to remove certain parts and replace them, these parts which are removed are also increasing the number of waste, and of course to calculate it and to make some kind of fundamental proof and whether such kind of provision would have this effect which is expected here, it is probably not possible. It is a kind of belief that it will help, but not really from the observation. And therefore, if we can argue that in certain areas of the market, such kind of priority for repair may cause a kind of fragmentation of market, it will be a problem of competence based on Article 114. But another issue is, and probably this is a question for private lawyers, so this is more interesting actually from my perspective, is the question whether this provision, like it has been formulated, works. And have us a look on this Article 12. Interrogation from the first sentence of this paragraph, where the cost of replacement are equal to or greater than the cost of repair, the seller shall repair the goods in order to bring these goods in conformity. It is differently written from the general concept. Generally, the consumer has a choice. I have a choice between repair or replacement. The seller may defend itself by making this objection of disproportionality. So telling this chosen way is much more expensive. I'm not talking now about the absolute disproportionality, it does not matter here. I'm talking about this relative disproportionality, which means the relation between costs of two remedies. And now we have this, the rule. I can say, oh, I will do repair because it is costly more reasonable. And for instance, in Germany, this difference between repair or replacement, the cost of repair or replacement, yeah, it is about between 25 and 30%, which is the quite stable case law on it. But if one remedy, for instance, more costs more than 25% or 30%, it could be unreasonable. In such situation, we can resort to the other remedy. But of course, the seller must raise this objection. So it does not work automatically, but it must be raised. So it is a kind of subjective entitlement of the seller. If he does not say anything, the choice of consumer is affected. This 25 and 30% means also that there is, of course, a quite huge scope of assessment for the court. So the court is not really, it does not matter, it's really 25, it's 26, it's 28. It is just a little bit a kind of direction which we are going in it. So we are trying to assess the values, and according to all circumstances, it will be unreasonable. Here we have a different system. Firstly, it looks like as a mandatory provision here. So in the case where the cost for replacement are equal or greater, then it must be repaired. It is not a choice in this way. It is not defense of the seller. It is a mandatory provision. So it means the buyer has not this right. It could be quite difficult with also with process system, with procedural rules, because I will claim for replacement and I will lose because, of course, the replacement is, of course, there are this judgment between termination and the price reduction. Maybe it will be applicable. Maybe we can go in these directions, but at least it will cause procedural issues. Then, of course, the problem, how to prove it. I have actually now to prove all these conditions that I have right to repair, because it is formulated as a mandatory provision. Where is the burden of proof? Does it mean that if I am trying to claim for replacement, I have to make a proof that repair is not cheaper? And of course, here we have very strong formulation: greater, equal, or greater. What kind of costs? Which costs we are taking into account? The cost, there are many costs which we can calculate into it, and of course it's completely out of the proof of the consumer, so it is not possible that he will make this proof. And it may happen very often that there is no interest of the seller for repair. Why it is happening so? In different categories of products, we can take clothes, for example. Yeah? The clothes are produced in so-called, unfortunately, cheap countries with cheap costs. To repair is much more expensive. I have to check everything. I have to have the local forces probably, or people who are dealing with it. Is it much cheaper to replace than to repair in such circumstances? So very often we cannot really count on it, but the seller will be so happy about cooperating in showing that the costs are different. Depends on category of products. In some products it is evident, but in cars, in car industry, of course, the repair is cheaper than replacement in a majority of cases. But it is not true for a lot of categories which we can imagine. It varies. It is quite different. If we say this is a mandatory provision, we don't know exactly, because the directive has so-called semi-mandatory provision. Semi-mandatory provision means that you can deviate from the rules of the directive in advantage of the consumer. But here we have another incentive. We don't want to protect the parties. It's not the right of consumer to make you more happy. It is right to protect the environment, the public interest. So probably this is a mandatory provision. You cannot deviate in both directions. So cannot be more. We cannot agree on to relax this conditions in benefit of the consumer. It will be probably void. If it will be void, we will have another interesting question: what is happening when the illegal replacement will happen? Does it mean that it is unjustified enrichment and we have to return all goods with all externalities and then to make repair once again with another additional costs? Or no, this is probably a nonsense development. It is a nonsense development because nobody would care. So if the parties, of course, agree on replacement, they will replace and nobody would look on it unless there is something wrong with the replacement, and the story will start again and again and trying to have another argument about it. So this provision must be probably reformulated if it should work. So it must be put again into the structure of defense I don't, maybe this criteria for cost should be somehow relaxed, but it must be clear that the seller should defend him or herself by, of course, proving this cost. It must be determined which costs are taken into account, because of course, if I have a mass product, how can I calculate the cost of this particular product if I putting in just en masse? So there is costs of employees who are working on it, are costs of recycling, maybe depends on existing provision, even on storage of transportation, depends very much on thousands of factors which are not operable to this extent. Another question is, of course, it is also related to the private law issues as being mandatory. Can we settle after the lack of conformity arrives and for replacement? Basically, even if the rule is mandatory, I can settle. I can resign in certain entitlement in order to settle. But this rule is mandatory for very public interest, and also a settlement will undermine this idea. So this is a kind that it takes out of the private autonomy. And then here we are in the core of the problem: what private law can do and cannot do. Of course, there is a lot of mandatory provisions. There are also mandatory provisions which protect the public wealth and not only the interests of the parties. But here we are trying really to input into basic behavior of the parties, kind of elements which could be against interest of them, and then the private law would not work. Actually, this results will be never achieved. So I think to get to the conclusion that we have here a problem on several levels. The Commission was not courageous to say, oh, we have to really reshape the directive and make it more efficient, because it was quite clear that these difficulties which I have discussed to make a sufficient proof are quite high. And then a little bit to say, oh, we are trying to build in some obstacles to the market, but we will get for this incredible benefits for our sustainable development. It is very difficult to make such a kind of proof on this level. Then we have a provision which has been formulated in the way, of course, it could be a matter of interpretation at the end of the day, but how it is formulated, we are reading it also in the context of the whole provision. It looks like that my theory about this mandatory nature and this and depriving of this provision, the effect of defense, which must be raised by a party. This makes it very difficult to use in practice. And based on this, we had a small experiment whether the private law could help. This experiment is, of course, not put to the end, because this provision has space for being improved. But nevertheless, in the end of the day, we wouldn't be sure whether on such level it will bring any advantage to the environment. What could be the idea, and this is something which is, Hugh was talking today about this, and we have it already. We have this system of different categories of products, and then different requirements for labeling. Even the this right to repair directive refers also to the annexes and different category of products where it works. Probably the only way to make it somehow operable would be to go into this direction which Christoph Busch, my colleague from Osnabrück, proposed in another context, some kind of granularity of the system, where you will get, based on empirical data, I don't know now, artificial intelligence, your own set of remedies at the beginning of the contract to make it much more efficient for in this particular case, because everything will be calculated. But we are at this moment quite far from such kind of instrument. Thank you so much for that.
Well, thank you. I think there's a lot of food for thought, and it came to my mind after listening to you and the Hugh that the saying goes, "The devil lies in details." And we definitely are in a very like situation on this part. So I think there's going to be much to discuss about that. But let me now turn to Chef Manette, and I don't think I don't need to introduce it to you because all our students first and second year know him, but he's been for many years professor in Maastricht and is now working in Amsterdam and regularly teaches in our courses. And he's actually making a presentation on a very new topic, dealing with managed retreats. That is what happens when, due to climate change, severe events happen that make it impossible for people to live in their house because they are flooded or there are other events, fires and so on. And again, private law is in a difficult position because the way that property rights have evolved over time are strictly related to individual use of movable goods. But on the contrary, when it comes to this kind of phenomena, there's a collective dimension, and of course, it needs to be assessed how far private law rules are suitable for that. So,
we're looking for the power.
Oh, no,
Yes.
no, it's here, probably
did you
here.
get it? Because I looked at that.
It already was there.
It's ready, yeah.
Yeah.
Sorry.
That's okay, go on.
Sorry, I thought it was.
That's okay.
I
No.
we opened it, but probably something was wrong. Oh, it lost a file because it went out of the system after a certain amount of time.
Okay, that's-
That was it. Sorry. Okay.
All right.
Did we share? Probably we didn't share. With the, with the sharing it on.
Okay.
No, sorry. So.
That's it. Otherwise, yes. Okay, all right. Right, well. Thank you for inviting me, and it's a pleasure being back also in this company, in this roundtable. And it's also really good to see all of my students. I'm going to talk about, well, managed retreat, and as you can see on the first slide, it looks a bit threatening, and in a sense it is. There are a few remarks to begin with. Now, Hugh said, you know, it was talking about Brexit and the United Kingdom not being part of the European Union. I think for this topic, that is completely irrelevant. We are talking about global problems, and the UK still is a part of Europe. And so what happens in the UK, and I'll give you an example, is also relevant for us. So questions about are you inside or outside the European Union are absolutely not relevant here. And second, I once, a few months ago, listened to an online lecture by a colleague who had a map showing what the rising sea level would mean from, let us say, from Paris to Hamburg. And about the consequences. I'm going to talk about these consequences. She came from the city where I'm now working, Amsterdam. And at the end, I asked her the question, so what about Amsterdam? And she looked at me like, no, we are not going to flood. And I said, but listen, you just showed us a map. So there will be flooding from Paris to Hamburg, but Amsterdam not. And there is also something. We just don't realize sometimes what we are seeing and what we are saying about the consequences of global change, global climate change. It's not theory. It's not an academic exercise that we are talking about. We are talking about what is really happening. So let's start. I think it's this one. Should be this one. That's that flick. That should do it. Yeah, there we go. Now, I've split this up in several parts. First, what in fact managed retreat is, where it comes from, the whole idea. That we are talking about different situations, that it has various aspects. What the role is here for law, that was a point already discussed. And what the role is here for property law. So let's see. Now, first of all, what is managed retreat? Well, the idea was developed first in the United States, where they were confronted with areas close to the coastline, where whole communities had to be relocated. Sometimes on their request, sometimes not. And how do you do that? But the idea is particularly developed in New Zealand. In documents, papers published by the New Zealand government, where they say we are in an area that is at risk. We are in an area where the rising sea level may result in certain smaller states in Polynesia and so on, which might completely vanish. And New Zealand will not really vanish, but parts of the country will be flooded permanently. So let us start thinking now what that means. So not react in panic in case we have a disaster, but let us anticipate what is happening. Anticipate, thinking, okay, of course we should try to avoid this, but in case it all fails, then what? Now, in this New Zealand government paper, they define managed retreat as or areas where managed retreat should take place as areas considered of intolerable risk and reduces or eliminates exposure to extreme weather events. And a program of managed retreat enables people to relocate homes, activities, sites of cultural significance in New Zealand Maori sites from at-risk areas within a planned period. So you move away. And what should you then think of? Because this still sounds fairly abstract. Well, first of all, managed retreat is a measure that is generally seen, and it should be seen, as a measure of ultimate resort. So if all else fails, what then? And don't think about science fiction movies where we all move in spaceships to another planet. Right? That sounds really interesting, but it won't happen. We have to survive here on this planet. So first, what we should try to do is avoid climate change from happening. At the same time, protect ourselves against the changes that already are happening. Avoid, that's what we've been talking about. Why do we need new iPhones? Why do we need new things if you can buy them refurbished and you don't need so many of the resources that we have, that in fact we may not have? So that is a way of avoiding the risk that managed retreat will have to happen. Let's be careful with what we have. Then if we see that it might happen, and we see that it might happen, let's protect ourselves. So let's say build a dam, build dikes, take care that in periods where there is not enough water, we took care that there are basins of water that we can use. We could also accommodate. That has to do with protect. So that you redesign, for instance, the way you build houses, that you take care that there is sufficient isolation, that in winter you can keep warm without using too much gas or too much electricity. But if it all fails, if it goes wrong, we need to relocate. And then what? Well, Vanuatu is one of the islands under threat of disappearing. And Vanuatu, together with several other states, was able to bring before the International Court of Justice a case asking the court for an advisory opinion on the following questions. What are the legal consequences under the obligations mentioned in the document, like the Paris Treaty, for states? So what are the legal consequences for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to states, including in particular small island developing states, which due to the geographical circumstances and level of development are injured or especially affected by or are particularly vulnerable to the adverse effects of climate change, and peoples and individuals of the present and future generations affected by the adverse effects of climate change, what Evelyn Terrain has referred to as we are colonizing the future. When they presented their initiative to put these questions before the ICJ, the press conference was given like this: to show we are disappearing, we are going. But it's not just there. In Italy, as you all know, there is Venice. Underwater every winter, and the water comes higher and higher in spite of the protective measure of having a dam. Right? The dam doesn't help. At least doesn't help enough. There is the famous Lake Hasia. It's another example, it's not coastal, but the problems were the same. People were living where a lake had to be created to produce electricity, hydroelectric electricity, and it resulted in this book by Marco Balzani, Resto Qui. I'm staying here, I don't want to go. And that is precisely the human disaster that is happening in cases of managed retreat. I don't want to go, but I have to, I have no choice. Torquay in England, where houses disappear because the cliffs disappear. This is what is going on. In the Netherlands, I can refer to basically our situation that we've had for centuries, but that is now proving more and more of a threat. This map shows the Netherlands if we would do nothing about keeping the water out. Half of the country would be flooded. It did flood, in part, in 1953, when our dikes broke through, and parts of the provinces of Zeeland and Holland were flooded. We now build a complete new system of dikes and dams, but will that system hold? You see, if it doesn't hold, this is what happens. Yeah. So In the Netherlands, we are now raising dikes along the rivers. We are thinking about, does this system that we built in the province of Zeeland still work? You have to anticipate, you have to be prepared for what is coming and not say we are in denial. And unfortunately, very often, people are in denial. So managed retreat has an impact on people. It has an impact on nature. And I'll say a few more words about that. It has to do with human rights. And I'll say a few words on that as well. With damages and property rights. Now first, people. People move. So you lose your home and you go where there is no home. And suddenly the situation within a country, the people within a country, is not different from the situation of migrants arriving in Lampedusa. You go and have nothing left. So basically, we get internal migration with the migration problems that we now see with what we consider to be migrants from outside. So migration will come to haunt us if we don't think about it now and be prepared. And as we all know, we are not prepared for migration. Then there is this impact on nature. You should understand areas can flood, but it doesn't have to be flooding that causes the problems. Areas can be getting wet, too wet. And that has an impact on what you can grow there. Because it has that impact, it lowers the value of land and so has an immediate monetary financial impact for the person owning land, like agricultural land. And the questions that come up are, who pays for the damages? Can you sue your government and claim that the government, by not doing enough, caused your loss of value? Is that, could you sue on the basis of tort? Or, and that's a question I ask myself as a property lawyer, can you go to your government and say, by not taking sufficient measures, you in fact expropriated me. You took away my value. And so pay me financial compensation so I can move somewhere else or I can take measures. But there's also quite a lot of denying here going on. Recently in the Netherlands, we had elections for our provincial governments. So our provincial governments, in fact, the representatives in the provinces elect our Senate. So these provincial elections have an impact on national policy. And the party, basically the Farmers' Party, won. And one of the leaders of that party is saying that the problem of nitrogen when it comes to agricultural land is not so much caused by the farmers, but by people hiking in nature. Right? Because so many people go hiking, that is what causes damage to nature, not farming. Can I qualify that as a state of denial? So denial doesn't really help us because things will change. We get to human rights here. You have a human right to be protected in your right of ownership. And if your ownership is taken, the government should compensate you under certain conditions. It has to be an expropriation. But when can we speak about expropriation here? In case you have to move, you have a human right to live somewhere, to have a roof over your head. to have some certainty of livelihood, and there is the human right that we live on a sustainable planet. How do you balance that? We can talk about that for quite some time and discuss it in theory, but what if your feet are in the water? Then it is no longer an academic debate, it is reality. So we have to consider human rights. We have to understand the impact of the damages. The damages can go to, as I gave in my example, that land gets wetter, and so certain products cannot be cultivated there anymore. But it can also be that you completely lose the object. It's underwater. Like in Lake Resia, where a whole village is now underwater. Well, was underwater because the lake is now dry again because of climate change. But the moment you no longer have access to your home or to your land because it's flooded, could you then argue that because there is no longer an accessible object, it makes no sense talking about property rights? Because what is the object of your property right if you cannot access it? That value is zero. And there is a debate, not unlike what I encountered in the area of digitalization, where the question was, if you have bitcoins, but you lost the public key, do you then still have the value of the bitcoins? If because you lost the public key, they're worthless. Is that then still an object? So property rights questions come up here. So can the law do anything about this? Or are we just discussing the consequences of climate change? Can we plan ahead? And that is what the New Zealand government wants. Can we think ahead? Can we prepare ourselves? Well, we are talking about a physical process, but it's for a considerable part caused by us. And human behavior can be influenced. And the way we do that is by rules. And that I found quite interesting to see, because in the past few years, I particularly focused on digitalization, where you see a comparable development in the sense that technical people developed all sorts of IT solutions, ranging from blockchains to smart contracts to what have you. And then later on, it was realized that perhaps this whole area should be regulated, and perhaps can be regulated, and that we can influence how technique is further developed, that it is not just an autonomous process. We have some means to do something. So let's look from that perspective at property law and ask ourselves this question: does the existing law still function well? Can we use the existing property law as we have it to think about solutions about, in my example, particularly managed retreat, so to prepare ourselves for what may come, or do we need new law? And I'll say a few words on ownership and on land use rights, knowing that these are just first attempts to think about this. And in my career, this is the second time that this is happening to me. When I gave my first talk about rights regarding data, the situation was almost the same. It was clear that data and IT developments had taken an enormous, were developing at an enormous speed. That there was suddenly blockchain, that there were cryptocurrencies, and what you saw happening was that some of my colleagues said, well, data is nothing, so we don't have to worry about it. And others said, well, data is really complicated, so let's not answer questions about it. And the problem there was that we didn't even know what the problems were. You cannot ask the right questions if you don't know which problems exist. So you have to understand first what is happening. So in part, I became someone who understood computer technology. I'm not a programmer, but I had to. Here the same. I'm now reading about what is happening in these coastal areas. Why is it happening? What measures are governments taking? But what might happen? What do we see happening? And in case a whole community has to be relocated, what happens? And then my image is, suppose the whole city of Amsterdam has to move to dry ground in the east of my country. What then? First, ownership questions. Now, when areas are flooded or at the risk of flooding, you leave behind your property and your property becomes worthless or inaccessible. And the question then is, what remains of your right of ownership? Not much. So this raises the expropriation question that I just put forward. But also, you move from one area to another. And in, I would say, most countries, certainly in Europe, when you move from one area to another, you move to an area where people already live. So where it is clear who owns which parcel of land and which house. Could you then just say to people living in the east of the country, well, you know, we have about 400,000 people coming, so you have space. So we put units everywhere and people can live there. If I look at the problems we now have already, how to deal with migrants coming from outside the European Union, I think this will create grave social unrest. So you have to think about this. You have to prepare yourself in case we have to do this. How? That's exactly what the New Zealand government is doing. They have one advantage: their population is far less than in the highly populated parts of Europe, and they have land. They have space. But still. So if you move people to areas where other people live, could you then say, as owner of a house in the east of the country, ownership is the most complete right to a physical thing. I don't want you. And if the reply then would be, yes, but you know, you have 3 bedrooms that are not used and these people are out on the street. Can the government then say, we want you to accept that these people start living in your house? Now you might say, what sort of idiot idea is that? It's not an idiot idea. This is precisely what happened in the Netherlands, and I know in some other countries, after the Second World War. When people had to be relocated temporarily because cities were destroyed by bombs, and you had to live somewhere after the war ended. It's the problem in Ukraine, where you have to move. And people have to accept you. And if you don't do it voluntarily, the government must compel you to. But it means that you will have to accept that your right to property, although protected as a human right, is not absolute, because there are other human rights saying these people are entitled to a roof over their head and you have space. It means that you look at property not from the perspective of an absolute right, but as a right you could share under certain conditions. And this is the whole idea behind the sharing economy. That property ownership doesn't have to be exclusive. as long as you regulate carefully what you're doing to avoid, let's say, miscommunication, problems among those who use that particular piece of property. What we now also see is that we consider ownership not just as a right, but as a source of social duties. That you are the owner, but you also have a public duty to take care of what happens to others. The expropriation point I mentioned, this point. When we start redefining ownership in this way, ownership is becoming a way of allowing certain people access to a particular object. And that is exactly how we solve ownership problems in the digital world. It was clear that you cannot own a Bitcoin like you can own a pen or a computer. Ownership in the digital world means access, control. When we start sharing land, sharing houses, sharing resources, we talk about access. It's about access. So we should rethink land use rights. But we have this limited number of rights, the numerus clausus, but how limited is that list in cases of emergency? So we should really start thinking about commons, but not as a theoretical concept that we can debate for hours and hours and hours, but as a realistic solution to actual problems. And here we see also that traditional approaches to private law are gradually changing. Because sharing can happen in many ways. It can be imposed, like the example I just gave. It can be done by contract, and that is hiring, that already was mentioned. Hiring goods. It means that you share the good. You have an owner and someone using it, and you can have several people using it. So we need to think perhaps about new types of secondary rights. So some of those examples already exist. New types of easements, conservation easements. A different approach to what property lawyers call the accession principle. When you have, let's say, a house, that everything that is connected to the house belongs to the owner. That debate already is going on. If you have solar panels on your roof, why would you, because of the dogma of accessority, why would the owner always have to be the owner of the panels? Why can't you have an approach where if you put panels, solar panels on a roof, a company owns them and hires them to you? So dogmatic thinking should not stop us from looking at practical solutions. And comparative law can help us there. So my conclusions. Now, what we are talking about, managed retreat, is an ultimum remedium, is something in last resort. It's the last thing you do. You don't want people to relocate and leave their homes and live somewhere else. But you have to think about it. And I gave the example of retreat from coastal areas, but there are other examples. When thinking about managed retreat, how to set that up in a legal framework, we have to balance. We have to balance human rights. We have to balance how to share the burden, and particularly share the burden in an equitable way. In French administrative law, they have the principle of égalité devant les charges publiques. So it cannot be that one citizen carries the burden because it is in the interest of the general public that something happens. So if you have to relocate because of the rising sea level, the government should help you financially, should not say it's your problem. So I think we should start thinking about this quite fast, because these developments are going quite fast. Not to say, well, look at me how much I travel, but I was in New Zealand a few weeks ago, shortly after the cyclone Gabrielle, and they told me that until this year, cyclones almost never got to New Zealand. They now come far more south with devastating effect, particularly in coastal areas. Recently, in New Zealand, they had a whole series of tornadoes. They never had tornadoes, or hardly any. So things are changing very quickly. At the same time, we still all want to go on our weekend to Barcelona. We want to travel. We want to have our gap year. If we have to choose between a refurbished phone or a new phone, we want the new one. So let's also start looking at ourselves. Thank you.
Long discussion, a number of issues, so let me just very quickly try to wrap up. First of all, thank you to both to the participants, but also to the students, because your questions were all absolutely relevant, and I think it's exactly the exercise about getting the right questions, because you need to have the right question in order to get the right answers. So thank you very much for that. There are a number of issues that I think are coming back in a number of explanation and of issues that were raised. One is about legal taxonomies and categories, because the recurrent theme is categories are now getting blurred. Private law, public law, substantial law, procedural law, national law, international law, things are moving on. And of course, I think it was very interesting to see the different emphases, because Evelyn and yours, it was, that's good. We need to blur the categories because boxes don't work. And then the other two items were, be careful because the devil lies in details, and if you throw up things that are belonging to different kinds of fields, you may end up in trouble. Wishful thinking, ideas are good, but then when you come on the ground, things don't work. Evidence and so on. So this is something that our lawyers need to be aware. These are boxes. Legal categories are not physical entities. We construct them, and we construct them because they are useful for some purpose. But then if the context and the situation varies, then they might no longer be useful, and they'd be what we call a camicia di forza, convoluted. So you have to shape them and reshape them. And this is an exercise that we need to be able to make. Lawyers, the term comes from economics, but it fits very well into lawyers' mind frame. We are very fact dependent. We tend to keep on using our Roman ideas and so on for very good reasons, because legal certainty is important. So mixing it up every 5 years doesn't do the job. But that comes a time, and this was Evelyn's point, when you need to change the paradigm, that fundamentally things are not working. It's not just the detail, the boxes are wrong. And we might be into that point, that was a little bit underneath your ideas. Now, sometimes we just need to get the glasses off, because, for example, on commons, that is different way of understanding property, we do have a lot of that. In medieval times, we had a lot of that. Then French Revolution got rid of it. Common lawyers are far more familiar with the idea. But for example, Evelyn Ostrom, Nobel Prize for Economy, has been shown a different way of thinking about property rights for communities. Paolo Grossi, most important legal historians in Italy, has been writing extensively on a different way of owning things. So you need to be creative. We need to be creative. But there's a problem. Everything that comes out in terms of climate change, environmental protection, sustainability, makes clear that time is of the essence. We need to speed it up because changes are coming quickly. We are in a state of denial, and even if we are not, the problem is that we might come quickly to tipping points. Whereas legal development is slow. We need to have graduality and work at the margins of things. So there's a mismatch between the need to be acting quick and the fact that legal categories are slow to evolve, and even more, and this was something lurking in the background of many of your interventions, is that the political process works on short-term basis. You don't want to take into account what's happening in 2 generations' time. You want to be re-elected next time. And you don't want to tell the people that their houses are going to be torn down by floods or whatever. You just say, oh, it's going to be settled. And so that goes for artificial intelligence problems, data problems, migration problems, environmental problems. So there's a gap between what we need to do, and scientists are telling us you need to speed it up, and then having a legal process, but even a political process that is not geared for that. So that's why we really need to be aware of what is on the ground, because the first item is to get out of the idea of emergency. This is not an emergency. Your house being turned down is an emergency, but the phenomenon is structural. It's not an emergency. Emergency only signals the fact that time is crucial. And in order to do that, you need to be aware of the problem. So you need to have data, and that's why interdisciplinarity is so important. You need to work with economists, with sociologists, with climatologists, physicists, and so on. And we need to be aware that we can't get rid of what we have in terms of legal categories, but we need to be able to think out of the box. And that's the job. So thank you very much.